a maybe, right? So where you have very little involvement as a business owner, as a business, in the operations of the business, so the manufacturing, the packing, the supply of the ingredients, even the delivery and the retail of it, then the chance that you did something that caused something to go wrong is probably low. That doesn't mean that you're not going to be responsible first and foremost at law. In fact, it's usually the case that you will be responsible because the name on the tin, the supplier of the product, is responsible under the consumer law. We have a handy dandy thing under the consumer law that looks at this exact situation, and that's called the manufacturer's indemnity, statutory indemnity at law. You may also have, if you've got good contracts in place, a contractual indemnity, which will address, okay, where is the line between what you're responsible for and what I'm responsible for? In food business, you gotta kind of budget for and expect that something's gonna go wrong at some point. People can be doing all the right things and something slips through. We put processes in place and good businesses stick to those processes so that we can A, minimize or prevent things going wrong, but B, also catch it as soon as possible and minimize the impact on your business. So that's testing for allergens, that's having really good records in place of where ingredients are coming from, of what line in the manufacturing plant is being used for what kinds of goods. You can also control your risk by working with manufacturers who have limited use facilities. You're highly unlikely to get dairy as an undisclosed allergen if it's a dairy-free facility, for example. You're increasing your risk of stuff going wrong if you are making really explicit claims or declarations about the product being free from some kind of allergen. I'm talking about allergens because that's the most likely thing to go wrong. It's going to cause you to have to conduct a recall or cause loss and damage to a food business. You can also have microbial contamination and various other things, but whether your manufacturer is at fault is a separate question, and actually kind of a less important question than whether they are responsible at law. So if you've got a contract in place that says clearly, well, you're responsible for this, this, and this is where it went wrong, and we can tell that because we've got records, we've got processes, and we can pinpoint it, which you should be able to do, then their insurance should apply. And this is a reminder that you always want to check that your manufacturer has insurance, and you want to consider the insurance position for your own business as well, and make sure as much as possible that there's no gaps, because that big recall event, no matter how big your business is, can be the end of your business if you don't make smart steps, smart choices to try and mitigate that risk from the start.